Hi, and welcome to today's podcast as I share some insight on why anyone in their 20s, 30s, and above should really start thinking about estate planning. Recently, my wife and I lost a dear friend to a car accident. It was completely random, and he was only 36 years old. But he left behind a beautiful wife and 4 beautiful young children. Now, when traumatic events like this happen, oftentimes we self-reflect and try to process this massive amount of grief, and even feel selfish in nature to ask the questions like, what if that happened to me? What would my family do? Are my partner and I really prepared? And these were just a couple of the questions that completely filled the conversations between us and our friends for the foreseeable weeks ahead. Now I fast forward 6 months later, and like many of you have felt the impact of this pandemic, along with other tragedies, and I've seen our friends and our family do their best to return to their normal lives. Unfortunately, many of them have put off taking the important steps to protect their loved ones. So I feel very motivated to encourage anyone listening and who has a family to seriously consider consulting with an estate professional to put together a plan that will help protect your family in the event of an arbitrary deprivation of life. And a common misconception is that you either have to be old or rich to have an estate plan, which is why a lot of young people avoid it. But the reality is that estate planning is important regardless of your age or wealth, even if you're young and have modest assets. Now, a question we get a lot is, well, what is estate planning? Estate planning is more than just deciding how you want to divvy up your money when you die. It also involves taking care of and protecting yourself, the people you love, and the things that are important to you. Our 20s and our 30s are often shaped by pivotal financial decisions and life events, such as graduating from college, buying a house, getting married, or starting a family. And while these milestones can and do make our lives fuller and more complex, they also underscore the importance of comprehensive estate planning, especially for younger adults. Now, having a few essential documents in place can really help ensure that you and your loved ones will be taken care of in the unlikely event something happens to you. And the essential documents you'll want to have in your estate plan are 1. A durable power of attorney. This is a document that lets you appoint a trusted person, such as a family member, to be your agent to make financial decisions on your behalf in the event that you're incapacitated or unable to do so yourself. For example, if you're traveling abroad, you might want to appoint someone to be your durable power of attorney to manage your finances while you're away. And this agent you appoint can withdraw money from your bank account for you and pay your bills. The second document you want to have is a living will. A living will is a document that allows you to specify the type of future medical care and treatment you receive should you become incapacitated. For example, if you're in a car accident or in a coma. A living will usually applies to terminal illnesses regarding decisions related to resuscitation, ventilator use, and artificial nutrition. And in some states, a living will is recognized as a legally binding document, while in others, it's just a statement of your wishes. And this is why it's important to consult with a knowledgeable estate planning attorney to help you determine if a living will makes sense for your situation. And a common question that comes up around wills is healthcare proxies. Healthcare proxies differ from a living will in that it grants another person the power to make those health decisions for you. And you can appoint the same person to be your healthcare proxy and your durable power of attorney, or you can appoint somebody different. And the third document that I like to go over is the will. A will is the foundation legal document of most estate plans. It provides written instructions for how you want to distribute any assets held in your name and lets you appoint a guardian for your children. It'll also name an executor who will be responsible for carrying out those instructions. And if you don't have a will, state law determines how your assets are distributed, which can take a significant amount of time, effort, and money for your loved ones. And the fourth document that is important to have in an estate plan is the revocable trust. A revocable trust is a written document of instructions for how you want your assets to be handled after you die. You, as the grantor or creator of the trust, can amend or terminate it at any time. Not everyone needs a trust, but for those who do, a revocable trust can be a valuable estate planning tool that helps you manage and protect assets while you're alive and allows your beneficiaries an efficient estate administration without having to go through that probate process, which can cost tens of thousands of dollars and nearly a year's worth of cumbersome legal processes to determine how your assets should be distributed. And that's just a quick glimpse into some of the key areas that you and your family should be aware of as you determine your needs. Now, every individual's estate plan needs are different, and the processes and laws for estate planning vary by state, which is why it's important to consult with a knowledgeable estate attorney for advice regarding your specific situation. Thank you for taking the time to listen today. I hope you take this topic under advisement and ensure you and your family are protected. Please don't hesitate to reach out to us and ask any questions. There's no obligations, and we're here to help you. Thanks again for tuning in, and hope you have a wonderful day.